We do not give out coupons, though. We give strawberry stamp cards. But an emphasis of my practice is on adoption and surrogacy related matters. So, and one component of the adoption practice that I'm involved in is the identity of children who learn that they're adopted and connecting with their original birth parents. In the past, historically, we have a history of doing a lot of closed adoptions where children did not know who their biological parents were. And so we get contacted to go into court, get an order to access those files. In Washington, adoption records and most parentage actions are sealed. So they're confidential, and you can't find them necessarily just by doing a search on the internet. Most of what I'm going to talk about today is going to be kind of Washington specific with regards to Washington practice. That's where I'm licensed, that's where I know. I'm not going to talk to you about other states. That being said, most of Washington law is adapted from the Uniform Parentage Act, which is a multi-jurisdictional act that has been adopted in many jurisdictions. So, for instance, Minnesota and Texas have also adopted that statute. So if you're from those areas, much of what I'm going to say is the same. Generally, in Washington, the process for going about amending your birth certificate, because that's what I was told was kind of the thing to talk about, was that how do I get my biological father my birth certificate? And the reality is that it's actually only possible for a few minority. It's kind of a complex process, and it depends on what's been done in the past. The way the statute is written in Washington is there's a statute of limitations on disputing parentage in certain circumstances. So if you are potentially the father who's not the biological father, so what do you call it? Birth certificate? Well, yeah, birth certificate. So the person who's been holding themselves out as your father has done so and signed a legal document, then his right to dispute parentage is limited. So even if you find out that that was not your actual biological father and you want to amend your birth certificate, you can't necessarily do so because of prior court orders which have thus adjudicated him to be the father. In Washington, we have the acknowledged parent, the adjudicated parent, and then a presumed parent. And those are written by statute, okay? A presumed parent is a person who is assumed to be the parent of a child. So either that's through marriage, relationship, or having intercourse within 300 days of the marriage. As well as with regards to surrogacy and parentage, that person has also been identified as an intended parent. An acknowledged parent is a person who's established their parent-child relationship through the administrative process. This is effectively signing an acknowledgement of parentage if they're unmarried at the hospital, which then results in which form is then transmitted to the Department of Biostatistics, and their name will appear on the birth certificate. That form, while it's voluntary to be signed, is binding for a certain duration of time. In Washington, we just amended our law on January 1st to allow for children to bring a petition to dispute their parentage if they were not a party to the initial action, which very unlikely they are or were.
Rachel, can I ask you, when you say children, you don't mean somebody who's under 18?
No. So there's two ways to do this. There's the adult child, and then you have a minor. In order for a minor to do something, which is under the age of 18, their action needs to be brought by a guardian or a parent. In Washington, there's two ways. Let me backtrack. Oh, sorry. I'm not used to juggling this. In Washington, there's two ways to change a birth certificate. Either by an acknowledgement of parentage, which is the administrative process identified, or by court order. You can establish the acknowledgement of parentage will establish a parent-child relationship and add a second parent to a birth certificate if one is not already listed. So if you have only one parent on your birth certificate, then this would probably be the process to go about with regards to adding a second parent. Now, if you have two parents on your birth certificate and you want to change one of them, that needs to be done through a court order. That is new territory in Washington as of January 1st. So it's novel, it's new. We're trying to kind of going around it. With regards to a court order, this is when you have a question about who is actually the parent of the child. This is only for Washington birth certificates, though. I want to note that. And the court will have jurisdiction where the birth certificate was issued. So you need to identify initially, before undertaking an action like this, where you were born. And that's where the proper jurisdiction is to bring an action. So if you were born in California and you're now living in Washington, you need to go back to California. because that's the court that's going to have jurisdiction to order the Department of Vital Statistics to amend your birth certificate to reflect what you want it to. Washington doesn't have authority over other departments of vital statistics. Birth certificates are issued by statute. They're not a court order. So unlike court orders, which have the full faith and credit under the U.S. Constitution and other jurisdictions, the birth certificates don't. So they're not binding. Whereas an order from one court isn't going to be binding on a Department of Vital Statistics in a different state. You need to go bring your court order from a different state to that state, get an order issued in that state, and then they'll amend your birth certificate, which is a very long, drawn-out process, and there's no guarantee. So if you're attempting it, I recommend you go back to where your birth certificate was, find a family law attorney, which most family law attorneys will probably be able to do this process. It's very much a part of family law. That being said, use your best judgment when hiring attorneys. They're sharks, I know. But that being said, so there's some potential pitfalls when doing this, though, that I want to, really caution. And that is secret interfamily adoptions, which were very common in the Midwest and on the East Coast. And in those situations, it might not be possible to amend your birth certificate. Many states will issue a new birth certificate after an adoption that does not reflect that a child is adopted, like in Washington. A birth certificate will not show a child was adopted on the birth certificate. So therefore, you can't know whether you were adopted by a birth certificate. Affairs, that's one. Children born via assisted reproduction, so via sperm donors. If a child was born via sperm donor, in Washington, a sperm donor under statute is defined as a parent without parental rights. So they will not necessarily be able to appear on your birth certificate and have it amended to show them. Deceased parents. Courts are going to require genetic testing in order to issue a order identifying to who you want your birth certificate amended to show. In order to do that, you need to have genetic testing. The genetic testing through Ancestry.com and 23andMe and the other genealogical sites is not sufficient for the court because there's no chain of custody. So when you're looking at this, you're going to have to go undergo genetic testing again to show to the court. In some circumstances, the court will say, okay, we don't need genetic testing because you've shown sufficient proof. And so in those cases, if you have such compelling information and it's not possible to do the genetic testing, the court may go ahead and still issue an order directing for the amendment of your birth certificate. That being said, there's no guarantees, and a lawyer's favorite words are, it depends. So everyone's factual circumstances are different, and there's no one shoe fits all with regards to this. Everyone's situation is different. The other, I kind of touched on the statutory limitations. In Washington, it used to be 4 years. So if a father signed a document or someone holding themselves out to be the father signed a document saying that they were the parent of a child in a hospital, they have 4 years to dispute that. If they don't, it's binding. That being said, if a court then subsequently enters an order of child support, child custody, a parenting plan, then it becomes an adjudication of parentage, and the person who signed the voluntary document identifying them as the father is then becoming an adjudicated parent, which is then much harder. When you're looking at going in and changing a birth certificate, there's a lot of ramifications and implications it will have, not just on the identification. This has major issues for child support, child custody if the person is under 18 years old. In addition, it has major inheritance and issues. Because if you're talking about changing your birth certificate to amend to show that someone else was your father, you're effectively going to be disinheriting all right and claim to the other parent's estate. So if you have a parent who already appears, by changing the parents, you will no longer be considered an heir, in which case, for their estate planning documents, you will need to be identified specifically by name if you were to share in that estate at all, because you will not be considered an heir. For the person you are asking to be added to your birth certificate, that individual, if that person is deceased, you've got major implications because that person's will has already been written and it's already established. And the language that's in wills nowadays is a blanket statement for and all heirs, which has major ramifications for people who show up post the individual whose estate's being litigated, they're deceased. And so once they're gone out of the picture, they can't change their will, but their will says and all heirs. Therefore, you become an heir after the fact, which would have implications on then your sisters and brothers that would then be a part of that estate, and all of the inheritance rights that implicates. So there's major ramifications for changing your birth certificate, so I would not, tread lightly. If you can do it by agreement, that's always best. But we understand that that's not possible. Based on what I do, that's, if you're in my office, it's usually because it's not possible. In which case, we can go ahead and go through the process of determining who, once you have identified who your father is, or your mother, whichever one it is, it then starts by filing a petition, asking the court just to go and change the birth certificate. At which point you need to show sufficient evidence that this person is your father, and which includes, all of the testing that you've done through 23andMe and Ancestry.com, the family trees, the evidence and documentation you have showing, why this person is this person, and a narrative identifying your entire story, basically. So showing why you think this person is your father, why you think this person is your mother, and how you know it to be true. At which point the petition will then be served on the alleged parent at that point, because a person is only an alleged parent until they're an adjudicated parent. Once the alleged parent has that opportunity, they will then be able to respond. If they are deceased, then you're going to file against the estate, so of the deceased individual, and then you're going to identify the administrative or personal representative of that individual. Once you then initiate the action, if they don't respond, the court can grant your decree by default and say, okay, you know what, they didn't respond, we're going to change your birth certificate, that's great, you're good to go. But the reality is also, the court's very aware that things are being done here that have major implications that someone might not be aware of. If someone's deceased and doesn't respond, the implications that come out of changing your birth certificate, unfortunately, can have devastating effects for people's inheritance rights and legal responsibilities and obligations. So the court is going to tread it very, very lightly. It's a constitutional right to be a parent, and we're not talking about going back and changing who is a parent without their consent or say in a default proceeding. The court's going to tread very lightly with regards to making sure that everyone has an opportunity and a voice to be heard. I didn't say at the beginning, though, that if you have questions, you can ask it. I'm getting a lot of really blank stares, and I'm sorry. It's really dense. It's not very exciting to talk about legal jargon. Yes, sir.
On the inheritance, just a hypothetical. If I found out I had a sibling, and my parents had been dead for some amount of time, and their will has already been executed, what would be the outcome at that point? Would me and my siblings need to compensate the new sibling?
So not necessarily. If the will has already been probated and the estate has already been disseminated, it depends also, though, on whether you have one or two parents, and if one is still living. If one is still living and only one parent has been deceased, then you might still have a claim to the estate of the living parent. So if the father is deceased, but your mother is still living, and she is, then before it goes down to your siblings, it would go to her necessarily. And so in which case, whatever is left to be disseminated after she's deceased, then you might share a part in that. And in which case, then people will need to start going back and rewriting their wills to exclude people. And so we're talking about language saying no longer saying and all heirs to being only named heirs identified within, or no heirs identified after deceased.
So if both parents were deceased?
If both parents were deceased, then very likely you wouldn't be able to share in any of it. But really, I would check with an estate planning attorney in your jurisdiction before you proceed. Yes?
If a child support enforcement paternity test was done, would that not be sufficient to remove a birth certificate father from your birth certificate?
Can you say that again?
A paternity test ordered and initiated by child support enforcement, by essentially the state, deeming that the name on the birth certificate is not the actual father, could that be sufficient grounds for removing that name from the birth certificate?
So a determination of paternity that you're talking about is going to be effectively an acknowledgement of parentage through the State Department. It's an administrative process through that department. It won't, just because someone isn't a parent, it won't necessarily mean that their birth certificate is going to be changed. The court has to order that specifically. So they'll determine birth that they're not the father, but it doesn't mean the birth certificate is going to be changed unless you specifically identify that in the order that's determining parentage.
Okay.
Okay? Does anyone else have a question? Oh, wow. Yeah.
19 years ago, I had my daughter, and I did a older maternity test that had two possible fathers. The biological father of my daughter has no custody of comprehensive limitation born due to his bad habits, but she was raised by my husband, who was the other potential father. And he's been raising her for 19 years, but her biological father is on her birth certificate. Now, would she be able to petition the court to get the biological father off and put my husband's name on there, because he's raised her? That's her dad. And that's what he said this morning was, if you can ask that question, because he would love to be on her birth certificate. He's raised her since she was a day old. And so that's what was my question.
Yeah.
State of Washington.
So in the state of Washington, if you have someone who's been raising a child as their own and holding that child out as their own, and is not the biological parent, you would kind of have two options. You can either have that person file for de facto parentage in Washington, in which case they show the court they've been acting in the status of a parent, they have all the responsibilities of a parent and have been holding themselves out as a parent, therefore they should be considered a legal parent, or you can go through the process of having a step adoption.
Okay, because she's an adult now. She's 19.
Okay, you could still do an adoption.
Okay, because that's what I want to do, because he's deserved the right.
Yeah. So if you're doing an adult adoption, the really what you're looking at is you just need the consent of the child. Adult adoptions are much, much easier to do than a child. So yeah, no, you're looking at just doing an adult adoption then.
Okay.
Yeah.
And
No.
we just petition the courts for that one?
Yes.
Okay, perfect.
Yes.
Thank
Yes. No. That was a good one. That's an easy one.
you. Thank you.
Yes.
Does the birth certificate add, the presumed parent, if you're going to change it to your biological father, does he have to sign off? Does he have to give permission that his name is no longer on the birth certificate?
So the question is, does the father who's the presumed parent who's on the birth certificate have to agree to be removed from the birth certificate, right? Okay. So yes and no. They're entitled to notice. And in which case you have to let them know that you're petitioning the court to remove them because they're a party with it, they're an interested party. So in which case you're talking about challenging parentage. And so all interested parties need to be given notice. The person who's on the birth certificate, the person you want to add to the birth certificate. And then you have to go to court and tell the court, you know what, here's why this person shouldn't be on the birth certificate. And then the court is going to determine what's in the best interest of the child. That's the standard the court will look at. And so in that situation, what will probably happen is the court will determine that the person who's on the birth certificate isn't actually the parent, therefore they shouldn't be on the birth certificate, and they'll amend it to show that the parent who is the biological parent that you have. Yeah. Unless that person has, and I mean, but then you have major ramifications of, well, child support and parentage prior. And so what happened in the past? Because if you have a absentee father, which is very common, in which case, parents got pregnant, they had a child, and and then one of the parents has abandoned or gone off somewhere. But they've been still providing child support. So you're talking about years and years of child support obligations that someone has been paying to support this child that they've been holding out as their own. While they may not be actively parenting, you're not required to actively parent. You're required to support your children. So I saw questions, I think, back there. Yeah.
So just want to draw your strength around the shift to reproduction side of the law. So is there any shift in the climate towards being favorable towards children of assisted reproduction, wherein they could be, because you said birth certificates are by statute, is there any climate change around the statute that maybe birth certificates should have an annotation or something added to the birth certificate, or to allow biological parents to be added later on? Or is it still really cold environment towards that?
So with regards to assisted reproduction, a biological parent via assisted reproduction is considered a donor. They do not have parental status, and that actually was just rewritten into our law that came into effect January 1st. Which is specifically to guard guard a parent's rights to parent their children, because a parent has a constitutional right to parent their child, in which case your law, if that wasn't the case, otherwise you're talking about like 4 people being involved in parenting a child, and as someone who's family law, that is not a good idea. You're talking about 4 people agreeing on where the kid should go to school. It doesn't happen, okay? It doesn't happen. And so with regards to assisted reproduction, that is something from the onset, though, that nowadays, current assisted reproduction, that donors are aware of. If you're going to go into a sperm bank or an egg bank and be a donor, you are signing away a waiver that's saying you are not going to have any claim to that child or seek that child out. That being said, it's very common in surrogacy contracts where we will write a clause in identifying that the carrier or the donor will be available and will provide information, and that the intended parents, who will be the legal parents of the child, will inform the child of who the biological parents are. Once the child turns 18, Washington law has actually really opened up so that no one is actually anonymous anymore. Egg banks and fertility banks all have to maintain identifying information of donors. So the egg bank and fertility clinic that you donate to, if you're a donor, is going to maintain all that information. And they will disclose that information on request of the child through court action. So now, really, no one is anonymous, but you can't change a birth certificate to reflect the donor, because the donor is automatically not considered to have a legal status by the fact that they are a donor.
Even if the child wants to change it.
Even if the child wants to change it. Yeah.
So if the person doesn't know where they came from in terms of the egg bank or the sperm bank, is there some kind of, resource that covers all of those places in Washington State?
So egg banks aren't regulated like that, unfortunately. They should be, but that's also why we have donor 4365, I think, who has like 50 kids out in New York. Very popular guy.
Yes.
Very popular. And so with that kind of situation, unfortunately, there isn't an overarching. Most fertility clinics, which are under the American Reproductive Association, follow those guidelines and do share information. And in Washington now, if a bank is using egg or sperm from an out-of-state bank, they're required to obtain all the identifying information that bank has collected. And if it's collected in Washington, they're going to collect it here, and then information sits with that sample, we'll call it, or the gametes, and be transmitted with those gametes wherever they go. So in which case, a child need only know what the bank was that the process was undertaken at to obtain that identifying information. So you had, I think.
I have a follow-up question.
Yeah.
If possible. So I read the Uniform Care Act, this is the last version that was published on the Washington legislature, and there's an exemption to that 18 information release law that they can only release it if the donor has signed that they will release it.
Yes.
So the donor can still try to maintain anonymity regardless of the law to collect this information.
Yes. But if you show good cause, the court will ask them to turn it over. So it depends.
Depends, yeah.
Yes.
So I think I know the answer to this already, but I'm going to ask anyways. And it's kind of a touchy thing. So as far as like adult children like myself, like my biological father, I've done extensive research. Unfortunately, I was not. The Washington laws don't affect me. I was born in Brooklyn, so. What are our rights as far as he won't test, and so do we have any rights, or do you have any suggestions?
So if the person you've identified as your biological father won't agree to genetic testing, courts can order it. In which case, if you go in and you can show, because I have a couple cases like that right now, where we don't have obviously we aren't in agreement. So in New York, what you would probably want to do is connect with a New York attorney and bring your action, in which case you'd be asking the court to order genetic testing. So that would be your first hurdle. In which case, you really have nothing to lose by asking the court to do it at that point.
Right.
And so if the court says yes, great, you can get the genetic testing. If the person who you're asking to be put on your birth certificate is deceased, in which case you'd be talking about exhuming a body, which that's a lot just put on someone's birth certificate. I understand that there's major ramifications with regards to identity and awareness for the NPE. Is that right? NPE with regards to that, but the court also is concerned about the deceased person's interests and this in their family interests. And so what they might do in that situation is the court can order for a relative to be tested instead. And so if they have a descendant, that person can then be tested, and they'll compare those test results to determine whether or not you are related.
But if he's not deceased,
If he's not deceased, then the court, I mean, depending on where he's located, because that's the other issue. When you've got say the birth certificate is issued in New York, but say he lives in Virginia.
he's in New York. Okay.
Okay, well then you don't have that problem. But in that problem, you'd have a jurisdictional issue because the court can't order someone out of state because they don't have personal jurisdiction over that person. But in your situation, what you probably want to do is just get an attorney to file a petition to request genetic testing and then to amend your birth certificate.
One last question, then we need to break. Anybody have one last thing they
Yes.
want to ask? You said that if you can change it by agreement, that's the best way, obviously. If you do that, do you have to hire a lawyer if all parties are in agreement?
No.
So what would your steps be? Just go to,
So if you want to amend a birth certificate, what you can do is you can go online to Google and go to wallawhelp.com for Washington specifically and type in change birth certificate, and they will give you a do-it-yourself help packet. I am, yes, an attorney, but I'm not in the business of doing everybody's, people are very self-sufficient. People are resourceful. You guys are very resourceful considering what you guys have tracked down and located and identified. You're all basically like little PIs. And so, I'm sure you all are very competent with regards to finding information on the internet. And so, that being said, really an attorney probably would be only necessary if it was contested, in which case you're talking about having oral arguments and motion hearings. And so, but if you're all by agreement, then it's just basically a form process. And really the court will order anything if parties are in agreement. As long as all the parties whose rights are involved are in agreement on it, a court will often issue an order.
does that mean, does my mother have to be in agreement or just my?
Yeah. So whoever's on your birth certificate right now,
Uh-huh.
you probably,
So
yeah.
on my birth certificate now is my mother, but my birth certificate father is deceased. Does that matter?
Yeah.
Okay,
Because they don't have a voice.
right.
They can't come to court.
So,
So what a court might do is the court can also sometimes appoint a guardian ad litem or a representative for that person in the legal action to identify that person's best interests,
okay.
in which they might identify that person's interest and say, yes, we'll agree because,
So the one who's on my birth certificate right now is deceased. So
Yeah.
It doesn't really affect him either way, right?
well, it does because you'd be then identified as an heir and change his lineage.
Okay.
So
So maybe you do need to speak with Rachel.
maybe you do need an attorney. Yeah.
Hi, I'm Catherine St. Clair. We had another person speaking at a symposium that we had in Texas who was only speaking on Texas law. But one thing that I'm hearing that's a common thread that you're saying, and I just want to clarify this so that everyone understands, because this is something that really disturbs me, is that our birth certificates, as long as everyone agrees and there's no contesting, you can do what you need to do to change it. But if even one person who's named on that birth certificate, meaning your parent, your mother, or your father, says, no, I don't want you doing it, they won't touch it in Texas. So that tells me I don't own my birth certificate. Even though it's me and the birth certificate's about me, I don't own it. My mother and my father own it, unless they're dead, and then I can own it. Is that true in Washington as well?
I would say yes and no. Birth certificates are issued by statute, which is why, and I wouldn't say necessarily that your parents own it or anyone really owns it, because it's a document maintained by the Department of Health Statistics for your state to determine information. So your birth certificate is a record for the state to identify what is going on within the state, which is why there's specific parameters about what appears on a birth certificate and how it appears. In Washington, we just got progressive and we decided now people will appear as just parent instead of mother and father. But all that information is coming through via legislation. So if you want to change how birth certificates are issued, you have to propose legislation. And that's how it happens. So maybe that's a cause of action for you guys. But you don't necessarily own it. They don't necessarily own it. It's just the court is very much concerned about everybody's interests. and everybody involved. And when you're talking about changing a birth certificate, you're talking about changing who's identified, who has responsibilities, who has obligations, who has inheritance rights to specific people. And so the court is very much concerned about people who are not allowed to have a voice or able to have a voice because they're deceased in that cause of action. And so they're going to exercise a lot of caution in proceeding. Also, this is kind of novel. The court hasn't had this issue coming up very often, so you're not going to get judges who often see people asking to change their birth certificates. I mean, you're going to have judges who you come in and they're like, why are we doing this? Like, why does this matter? And unfortunately, that is the current climate. They don't see it very often, and so you need to have a really good case if you're going to go in contested and try and bring an action to change your birth certificate.
But the point is, I think, that you, even if one person doesn't agree and they contest, you can go in and try to overstep the fact that they're contesting it.
Yeah.
The court may not agree with you, but you do have an option. So I think there is a possibility when mom's like, no, I don't want to do that. You can still, but then it just makes it more complicated.
You basically have to go to court and say, so if everyone won't agree to change your birth certificate, you have to go to court and basically explain why your position is the right position and why it should be changed and why their opinions should be disregarded. Yes?
So it sounds like what you're saying is it's more of a state record, sort of like if a lot line was recorded in 1920 wrongly and people can see it's wrong, would they change it? Is it important to change it now, yes or no? And the answer would be it's then.
Exactly.
Something like
Who
that.
built their house on that line?
All right.
All right, that's all the time I have. Sorry. I will leave some cards. If you have questions, feel free to email or call me. I'm happy to talk to you about it.
Her email's
Information's
also
power.
in the bottom here, too.